and you show the chart and go, let me tell you about the law.
Yeah, where's common sense on here?
Yeah, common sense isn't on there. It doesn't say it at all.
Yeah.
So one of the cases that becomes important, and these are out of the Court of Criminal Appeals. This is Fuller v. State from 2012. The question was, the trial court denied the defendant's request to ask members of the veneer panel whether they understood that the standard of proof beyond a reasonable doubt constituted a level of confidence under the law that was higher than preponderance of the evidence and the clear and convincing evidence standards. This case was reversed. They basically...
so the judge did not let in that, analogy, hey, beyond a reasonable doubt is higher than...
Well, if you really read through the whole thing, the court didn't let him get into the civil burdens of proof.
Oh.
Right?
Okay.
So how do you know how high beyond a reasonable doubt is if I haven't defined... How do I know how tall 6 feet is if I've never seen 5 feet?
Right. Yeah.
Right?
I've never had... have you ever had a court restrict... besides this guy saying... this one judge saying, hey, we've already gone over this.
Right, but that's what he's doing effectively.
True.
Right?
Absolutely, yes.
And so
you have every right, and if you are completely repeating what the state has said, you still have that right to do that.
Right. And so the Court of Criminal Appeals admits that the trial court has broad discretion. They can limit your time. They can say, hey, judge, move along. But especially when I'm trying to establish using standards of proof, what beyond a reasonable doubt really could be, I probably should have turned around and said, Judge, but Franklin v. State says that I can talk about the burdens of proof and the standards, Fuller v. State, I said Franklin, Fuller v. State, thank you, Mr. Harrod, pointed that out for me, says that I get to talk about that. I get to use those to help the veneer panel, to help the jury panel know what it is to hit beyond a reasonable doubt.
No, you absolutely could have. Should you have? You're already running late on time.
Right.
It probably. It is the crux of the case.
Right.
Of the
yes.
case.
Often the question is, am I in possession of something? Well, probably, but is that beyond a reasonable doubt?
Right.
Right.
Yeah,
If you
other people were in the car, how? Right. I get it.
Make sure you stay close to your mic, Mr. Harrod. I know we're on video, but got it.
I'm trying to not hide my face behind the microphone.
Please hide your face behind the microphone.
What? So, I guess, you learn, but practically speaking, I guess, you teach on this, Fuller v. State, and you can kind of throw that out there, willy-nilly.
Right, and the other case,
how many, in the moment, if you were 1 second, Your Honor, I do have case law on this, if you would like.
Right,
and so said, no, not necessary, keep going.
So I think sometimes to remind the jury panel, I know my stuff.
Yeah.
Right? I've already corrected the prosecutor. Now watch me correct the judge.
Yeah.
Right? You have to be, again, all of this is theater. You and I have talked about this before. All of trial is theater. We've all had things that we could have objected to, that we knew was going to come in, that we let it slide. Why? Because it's not going to hurt us that much. And it's just going to, you're not going to get anything out of it.
Yeah.
Right?
Well, I do think that can be very valuable in correcting, the judge or prosecutor, to show the jury, you do know your stuff, so long as it's done in a tactful way. But we try cases against the same prosecutors, kind of routinely, and so you kind of know when or what a prosecutor's going to say. Rarely do I or anybody else that I know change up their jury selection.
Yeah, I actually was doing an online solicitation of a minor case and thought I knew exactly where it was going to go.
Yeah.
and the state stood up and said, we're going to start, and they got out a whiteboard. Let's list off all the social media accounts you can think of. And they just went through and listed like about 25 of them from the jury panel.
Okay.
That's not at all what I was expecting. I mean, it's truly, and then they got back to what you normally. I went to the prosecutor later and I said, that threw me enough that I was like, do I need to change my approach?
Well done. Yeah. Well, and what I was going to say is that I know, with certain prosecutors, when I'm in trial with them, I know, like, okay, they said this last time. If they say this again, I'm going to object, and I'm going to have this as my rebuttal, right? So, like, telling the jury that the defense has just as much subpoena power as the state.
Right, they do that all the time.
That is absolutely incorrect. It's a misstatement of the law. The Secure Communications Act says so. So it gives specifically government agencies more subpoena power than little old you and me defense attorney.
Right. The other thing that you'll hear occasionally is about their open file policy.
Yeah.
Right.
Yes.
I think it's always handy, and it's in one of my papers that I wrote for jury selection, to say, especially if they mention it.
Yeah.
Because some prosecutors like to talk about everything we've given to the defense, right? They're trying to make themselves look like they have a little golden halo,
right?
To remind the jury at that point to say they've said this. It's true. They do have an open file policy, in part because Michael Morton requires them to. Because when they were not required by the law, it led to adverse outcomes.
Right.
That people were locked away incorrectly. You might get an objection to that, but they brought up open file policy, so I'm going to follow it up with law and why the law is there.
Yeah. Oh, that's great. I mean, I hear that all the time too, but I just kind of let it slide. Like,
no, that's one of those things that I'll come back. I've come back to and said, they do have an open. And when they're saying it, I nod, look at the jury like, yeah, they do. And I go,
now they do. Now they do.
Right. And it's because Brady and Michael Morton now require that information to go out. Jury selection, there's a lot. That's the problem. You and I have talked about this basically in trial. Part of why we're sitting there trying to be calm and we are working like ducks with their feet under the water, just churning, is that we're thinking about Fuller v. State, Sanchez v. State, Brady, Michael Morton. What's a challenge for cause? What's preemptory? How many challenges do we get on a felony?
Yeah,
right. We got that.
Yeah, you're right. Like all the basic elementary questions kind of go out the window when you've got like a guy's life on the line.
Yeah. And so I appreciate, for any courts that listen, we appreciate it when you hand us the sheet that has 1 through 10, 5, 42, whatever number it is, we don't care. If you hand it to us that way, we're going to fill it out the right way.
Yes.
But it's when the judge goes, make sure you turn in your strikes.
Just write them down.
Just write them down on a piece of paper.
That's when it's at those moments that I constantly second guess myself. Although I probably will never forget it, since the last time I had to text you.
That was years. That was a long. I think before we started the podcast.
Yes, that certainly was. It was a trial in a very small county, and
I get a text message just random. Right, I knew that Mr. Eric was in trial, and I get a text message. How many strikes do I get?
I was like, hey man, real quick, I'm picking a jury. How many strikes do I get again?
And truly, I was like, let me look. Right, so like both of us had that locked up moment. Why? Because there's so many things in your head going through your thought process.
It was not my first trial.
No.
Right? I mean, it's kind of embarrassing to admit, but I will say, like if something like that hasn't happened to you before, try more cases. They're going to start to like kind of bleed together a little bit. You're going to be focused so much on your opening or your whatever the very next thing in trial, that those small things it's just gonna slip. And for the life of me, I just could not remember it. And I don't mind being a little vulnerable on this show. Lord knows I've been in the past.
Well, we started with this that I realized I'm not sure I made a mistake, but I wasn't pleased with what I did.
Yeah.
Because for me, and maybe sometime we will talk about how I get to preponderance of the evidence, and we may have done it on the show. Clear and convincing evidence.
Right.
It has become for me like it is what I'm going to do.
Right.
And it's effective, and it raises the bar. And
You talking about the analogy? Yeah. We will have to talk about that. If it wasn't on our prior jury selection, I don't think it was.
Yeah, I don't think it was. I mean, it's almost one in and of itself. I've had judges say that that's worth the price of admission.
Okay, that's high praise.
That's high praise.
High praise. But I'm a good trial. I just want to I want to make that very clear. There, I'm a good trial attorney. Me forgetting that one little bit.
Mr. Herrick is a good trial attorney. I will give him that. So
I'm going to lose sleep over this now.
You should. You should.
But I will tell you. Thank you. I will tell you, though, it is extremely important. One, that you try a case with another attorney, although we often try cases alone, but also have other attorneys ready to answer questions when you are in trial, without you being there and having to look it up and.
All the time, and hopefully it's not to an email on the listserv.
Sure,
right?
Sure.
Sometimes we've all
direct contact. Yes.
Right. Occasionally we'll see an email on the listserv. I'm in trial right now, and you're like, you're hoping that
hours later. Yeah.
Yeah. Right. That was sent out at 10 a.m. and it's now 5, and I'm finally looking at that email.
Yeah.
So if you do something like that, make sure you've got lots of people available.
Speaking of, TCDLA does have a strike force in many counties for people in trial. I know the bigger counties have one, especially for ethical issues and whatnot. But please, this is a little plug for TCDLA. Join if you have not already done so.
Yes.
You were going to get on to, we got off on a tangent. What does Sanchez say?
So Sanchez is talking about the state basically may have biased the panel. This was somebody who had a physical disability from polio and was charged with a DWI, and the state asked the panel if they felt like that if it was sensitive or felt a need to be more protective of people with physical disabilities, and the defendant objected. But the whole case, it is all about jury selection. If you look through through Westlaw or Lexis, they'll have head notes.
Yeah.
Every head note is about jury selection. There are basically 17 head notes, all on jury selection.
Yeah.
It is just chock full of things. Like, what do you need to do? How do you make sure that you've used all your strikes, and you think that someone's biased and can't follow the law, and you have to ask for another strike, and if the court doesn't give it to you, you then have to say, well, Judge, I want to be clear, I'm striking juror number 7 because I believe they're biased, and you refused, and it becomes basically an automatic appeal. So several judges that I know have basically said, especially on felony trials, if you ask for another strike, they'll go, how many more do you need? You need 1? We'll give you 1.
Yeah.
Right? They're almost just going to give it to you because they don't want that possibility of the whole thing coming back on juror number 7 being on the panel.
This is to preserve error in that context, in that situation.